Hello friends, in the series on the income tax cases, today we will discuss a very important case in which the issue before the Honorable Bombay High Court through a writ petition was that whether the assessing officer is justified to issue the notice to the assessee for the assessment year 15-16 on the basis of a joint development agreement which is dated 9th May 2013, for which the relevant assessment year becomes 14-15. The issue before the court was that whether the AO was justified to reopen the case to investigate the matter to find out the possible leakage of revenue in the assessment year 15-16 on the basis of a joint development agreement which has been entered into the previous year 13-14. This issue came before the Honorable Court in the case of Paranjape Schemes Construction Limited versus Deputy Commissioner of Income Tax and others. This case is reported in 483 ITR at page number 353 and the date of the judgment is 10th November 2023. In the present case, the learned assessing officer was in a possession of a joint development agreement entered into by the assessee which was dated 9th May 2013. That joint development agreement was entered into previous year 13-14, for which the relevant assessment year was 14-15. But the learned assessing officer gave the notice to the assessee under section 148 for the assessment year 15-16 because the AO was of the view that the agreement has been entered into on 9th May 2013 and the incidence of tax or any other income is possible in assessment year 15-16 and that could be verified only through the verification of the joint development agreement. When the assessee received these reasons, the assessee was of the view that if the assessing officer wants to find out or investigate any leakage of revenue, then the AO should have opened the case for the assessment year 14-15 on the basis of a joint development agreement which is entered into previous year 13-14 and not for the assessment year 15-16. So according to the assessee, the reasons were not for the reasons to believe but they were reasons to suspect. So accordingly the assessee preferred to choose to file the writ petition in the court, and when this matter was heard by the court said that in the present case, in a writ petition, the court is not there to test the sufficiency of the reasons, but only the court has to check that whether the reasons recorded are relevant for making a reason to believe that the income has escaped assessment. So in the present case, from the pursuit of the reading of the reasons recorded, it is very apparent that the reasons are not relevant for opening the case of the assessee for the assessment year 15-16 and the joint development agreement which has been entered into in the previous year 13-14 cannot be a basis for escapement of income for the assessment year 15-16. So the court was of the view that in the present case the reasons recorded suggest that there is no reason to believe but they suggest only reason to suspect on the part of the assessing officer. Friends, this case is very important because there is a very thin line of distinction between reason to suspect, reason to believe, relevance of reasons or the sufficiency of reasons, which can be understood only by reading a number of the judgments in this regard. But in the present case, the assessee has showed a courage to go to the writ court, and the counsels of the assessee were very much able to present their case in a very positive manner and get the matter through a writ in questioning the notice under section 148, because generally it is a very tough job to get the notices quashed at the initial stage. At the end of this video, once again I am repeating the name of the case. The name of the case is Paranjape Schemes Construction Limited versus Deputy Commissioner of Income Tax and others. And this case is reported in 483 ITR at page number 353, and the date of the judgment is 10th November 2023. Thank you, friends.